Good afternoon, everyone, and welcome to this FedSoc Forum webinar discussing Humphrey's Executor ahead of oral arguments in Trump v. Slaughter. My name is Libby Dickinson, and I'm an Assistant Director with the Federalist Society's practice groups and networks. As a reminder, all opinions expressed are those of the speakers and not of the Federalist Society. In the interest of time, I will introduce our moderator, who will then introduce our panel of speakers. If you'd like to learn more about any of our speakers, you can access their full impressive bios linked in the Resources tab at the bottom of your screen or at our website, that is fedsoc.org, fedsoc.org. If you have any questions for our speakers throughout the webinar that pertain to the topic at hand, please submit them through Zoom's Q&A feature, also located at the bottom of your screen, not the chats that will be able to access them later. To that point, our moderator today is Elizabeth Slattery, Director of Constitutional Scholarship at the Pacific Legal Foundation. With that, I will hand things over to our speakers to start the discussion. Elizabeth, thank you so much for moderating today.
Thank you. Well, good afternoon, everyone. President Trump's effort to remove Rebecca Slaughter from the Federal Trade Commission has renewed attention on one of the most debated precedents in administrative law, Humphrey's Executor versus United States. In that 1935 ruling, the Supreme Court upheld limits on the president's ability to fire members of the FTC at will, reasoning that this independent agency was quasi-legislative and quasi-judicial. Since it didn't exercise executive power, the court reasoned that the Constitution did not mandate the president's direct control. For the last 90 years, Humphrey's Executor has shaped the structure of the administrative state, creating a class of independent agencies whose leaders are shielded from at-will removal. This raises questions about accountability and the proper scope of executive power. On Monday, the Supreme Court will hear oral arguments in Trump v. Slaughter, a case that squarely invites the justices to confront the future of Humphrey's Executor. This presents us with an opportunity to examine the doctrine's historical development, its structural implications, and its role in contemporary governance, as well as what a post-Humphrey's Executor landscape might mean for agencies moving forward. I'm pleased to introduce very briefly our panel of distinguished experts. First, we have Joelle Alicea, who is the St. Robert Bellarmine Professor of Law, Associate Dean for Faculty Research, and Director of the Center for the Constitution and the Catholic Intellectual Tradition at the Catholic University of America. That title is a mouthful, Joelle. Then we'll hear from Stephanie Barclay, Professor of Law and Faculty Co-Director for the Georgetown Center for the Constitution at Georgetown University Law Center. And last but not least, Erin Hawley, who's Senior Counsel and Vice President of the Center for Life and Regulatory Practice at Alliance Defending Freedom. So, Joelle, let's start with what Myers versus United States and Humphrey's Executor, two cases decided less than 10 years apart, where the court reached very different conclusions about the president's removal power.
That's right, and thank you all for inviting me to be part of this with such distinguished co-panelists. This is a hugely important case that's being argued on Monday, and as Elizabeth said, the story here really begins with Myers versus the United States in 1926, when the Supreme Court held that the president has the power to remove any executive officer despite restrictions on removal by Congress. So in that case, it was a postmaster who was being removed by the president despite restrictions on the ability of the president to remove that postmaster that were ignored by the president. And the court sustained the president's action, saying that the president has really absolute authority to remove executive officers without congressional interference. And that conclusion the court reached was after a pretty extensive analysis. Myers versus United States is a very long opinion by Chief Justice Taft that goes through the text and the history of the Constitution and some of the subsequent practice after the ratification of the Constitution to conclude that there was this power in the president to remove executive officers. And some of the arguments that are canvassed there, which I'll just briefly mention before we get to Humphrey's Executor, that Article 2, Section 1 vests the executive power in the president. And that seems to mean all the executive power is vested in the president, and the power to appoint is viewed as traditional executive power, and the power to appoint comes with the traditional power to remove whoever has been appointed. So absent some sort of textual reason for thinking that the president doesn't have the power to remove, that seems to come along with his power to appoint, which is specifically given to him in the Constitution. But the president also has the power, also has the duty to take care that the law be faithfully executed, and it seems to require that he be able to supervise those who assist him in taking care that the law be faithfully executed, and he can only do so if he has the power to remove them from office and put in place people who will help him take care of the law be faithfully executed. And then there was a really important debate in 1789 where the Congress, the first Congress, debated the scope of the removal power and concluded in what's called the decision of 1789 that the president does have inherent power to remove executive officers, at least principal executive officers. Um, and subsequent practice seemed to be pretty uniform up until the Civil War, with some controversy during Jackson's administration about the president's power to remove without congressional interference. So that's kind of a general overview of the evidence that Myers takes into account to support its holding. Then you fast forward less than a decade, as Elizabeth said, to Humphrey's Executor. Here, the issue was the removal of an FTC commissioner by President Roosevelt in the face of a congressional statute that limited his ability to remove for certain specific causes, such as malfeasance in office. And President Roosevelt made no pretense of firing the FTC commissioner on one of those bases. So he was just standing on the principle of Myers, saying, well, I have the authority to remove any executive officer, even in the face of a congressional prohibition. The Supreme Court sides with the FTC commissioner against the president in that case, saying Congress may limit the president's ability to remove executive officers of a certain type. And the way that the court gets around Myers is to say that Myers concerned officers who exercise purely executive power, like a postmaster, whereas FTC commissioners and a lot of this new breed of officers in these so-called independent agencies were exercising what the court described as quasi-judicial or quasi-legislative power. So they did things like make rules, which were quasi-legislative in nature. They did things like adjudicate cases that were brought by the agency itself. It's just a quasi-judicial power. And the court said that these were not powers that were part of the executive branch, and that the FTC therefore should not be considered to be housed within the executive branch in the same way that the Postmaster General is, and therefore not subject to the same kind of removal restriction power rather for the president that the postmaster was. And so the court proceeded to sustain the position of the FTC commissioner that he could not be removed without one of those causes in the statute being met. That precedent then becomes the basis for the constitutionality of what we now know as independent agencies. These agencies that are headed by directors or commissioners who are not subject to removal by the president except under certain specified statutory circumstances. And that precedent, Humphrey's Executor, endured for many decades without much controversy at the court, at least, until we get to some of the more modern cases. And I think Professor Barclay is going to go into those cases.
Yeah, so Stephanie, let's bring you in. Fast forward to, I'd say the 2010s, the modern Supreme Court has decided several cases now implicating the president's appointment and removal powers. So tell us about the recent legal landscape that leads us up to the Slaughter case.
Yeah, thanks so much for having me, and thanks to these terrific panelists as well. I'm looking forward to hearing your thoughts. So before jumping into the 2010s, just briefly, I'll highlight Morrison versus Olson, which is a case from the late 1980s. And there the court was upholding Humphrey's Executor 7-1 and upholding the Independent Counsel Act, which is, again, finding that these sort of good cause limitations are constitutional. But Justice Scalia there had a lone dissent that became quite influential. And it was one of the dissents he's most well known for. This is where he has the line, "This wolf comes as a wolf." And he really emphasized the textual argument that the executive power is vested in the president. That doesn't mean some of it, it doesn't mean a piece of it, but that means all of it. And he pointed out ways in which critics of Humphrey's Executor were raising concerns about the fact that these executive agencies are essentially operating like a fourth branch of government, accountable to no one within our separation of powers, or at least far less accountable than our constitutional system anticipated. So then we fast forward to the 2010s, and there's a series of cases that begin to really whittle away at both Humphrey's Executor and Morrison. So in Free Enterprise Fund, the court struck down dual for-cause protections for governing members of the Public Company Accounting Oversight Board. And in that case, those government officials could only be removed by the FTC Commissioner, who themselves had for-cause protection. And Chief Justice Roberts wrote that this dual insulation from presidential oversight violated separation of powers by weakening presidential accountability so much with that dual layer. And they pointed out that Humphrey's Executor just had one layer of for-cause removal. Then in Selah Law and Collins versus Yellen, the reasoning of the court that was important there, in Selah Law, they held that the CFPB structure with a single director removable for cause was unconstitutional because there, with the single director setup, they were exercising vast amounts of executive power, the court said, and so that was different from the multi-member agency context of Humphrey's Executor. And Collins versus Yellen likewise had a single director head of the agency that was insulated by this for cause removal. So those cases are, the trajectory of those cases has certainly been pointing in a direction of narrowing Humphrey's Executor at every turn, but that's also been true on the emergency docket more recently. So in May of this year, President Trump removed Wilcox from the NLRB and Harris from MSPB without citing statutory for cause justifications. And the district court had originally ordered reinstatement based on Humphrey's Executor, and the court 6-3 granted an emergency stay, allowing those removals to take effect. Similar sort of outcome in Trump versus Boyle, and in that case, the court granted a stay allowing Trump to remove Boyle from the CPSC and said that that order was controlled by Wilcox. Interestingly, Wilcox spoke about the way that the Federal Reserve is uniquely structured, quasi-private entity, and maybe has a distinct historical tradition. So one thing to keep our eye on with whatever happens with Humphrey's Executor is what will it have to say about the Federal Reserve, which is one of the elephants in the room. And that takes us up to Trump versus Slaughter. So I'll turn the time over to my colleague.
Thank you. So Erin, that brings us to the present case. Can you give us the highlights of the president's arguments and Rebecca Slaughter's arguments?
Absolutely. So as Stephanie said, first of all, thanks for having me. Delighted to be here with all of you. And as Stephanie said, President Trump removed Rebecca Slaughter as well as one of her colleagues, sending her a letter saying that he thought that she could not push his administration's priorities forward. So expressly did not rely on any sort of for cause removal, thus setting up the clash we see here in Trump versus Slaughter, and really a direct sort of question as to whether Humphrey's Executor still remains good law. So we'll canvass real quickly the arguments made by both sides. So the Department of Justice makes two primary arguments. First, they rely on the cases that Professor Barclay mentioned, cases especially Selah Law, Collins, as well as other cases the court has decided in the past 10 years or so, which really do seem to suggest that Humphrey's Executor might be limited to its facts. So as the Department of Justice reads Selah Law in particular, they point out that Humphrey's Executor, as Professor Alicia pointed out, was focused on the fact that these were quasi-judicial, quasi-legislative sorts of duties that were, quote, said to exercise no part of the executive authority. So this idea that sort of after Selah Law, after these more recent cases, that perhaps Humphrey's Executor really is only about a multi-member agency where it can fairly be said not to exercise any of the executive power. The federal government also points out, quotes a footnote of the chief first in dissent, and then makes it in the majority opinion in Selah Law, sort of recognizing the broad administrative law issues with these independent agencies. And they argue that these agencies have to be exercising executive authority because if they're not, what sort of authority is it? If it's legislative, then of course that should be with Congress. If it's judicial, then that belongs with the Article 3. So sort of this idea that whatever powers the FTC is exercising really do need to be executive, or else we've got other constitutional problems that the court will need to consider. So sort of the first line of defense or offense by the federal government is that SELA law, other cases have really narrowed Humphrey's executor to a place that doesn't apply at least to the current FTC. Since its decision in 1935, Congress has granted the FTC additional powers, including the power to bring civil actions in federal court, sort of a quintessential executive power. No one really disputes that. And so the argument is, even if Humphrey's executor was correctly decided, then the FTC has more powers than it did then. But the government also suggests that even the FTC decision, or excuse me, FTC in 1935 would, under the court's current case law, be exercising executive power. Finally, the court notes that if there's anything left of Humphrey's executor after SELA law, then the court should just go ahead and overrule it. And then there's another question presented that is actually kind of its own kettle of fish. The government makes the claim that even if Rebecca Slaughter is correct that she should not have been removed without cause, then the only available remedy is back pay, because it would violate Article 2, those clauses that Professor Alisea mentioned, to reinstate someone that would not fall under the executive's sort of purview, to just sort of appoint someone in a matter of speaking by reinstating them. So goes through sort of the historical types of remedies. Says that obviously courts in equity currently are limited to what the historical powers of equity were. So the respondent and petitioner go back and forth about what mandamus would have allowed, whether declaratory judgment changes that, and whether injunctive power exists. So with respect to sort of the substantive question, Rebecca Slaughter argues a couple of things. Interestingly, she takes sort of a Jacksonian approach to the question and suggests that all three branches of government have blessed the sort of multi-member agency exercising, some sort of executive power for a long time. She relies on Justice Jackson's famous concurrence in Youngstown, talks about all the presidents that have signed laws enacting dozens of these independent agencies, and sort of suggests Congress and the president and everyone has sort of worked it out. So the court should pay attention to that historical practice. And she also notes a number of independent agencies during the initial founding period. The government, of course, points out that those weren't exactly the same, so they debate that history. Finally, Ms. Slaughter relies on stare decisis. There's a lot of reliance interests at stake here. The government, of course, counters and says, well, that's a question of remedy, not necessarily constitutionality. But really where I think the biggest divide between petitioner and respondent is where one would expect. Is it constitutional to have that separation between the president and those in the executive branch, to sort of that lack of accountability that we've been talking about? And I expect that's where a lot of the court's questions will focus.
Thank you. So I want to invite audience to submit questions through the Q&A feature, but I have a few to get the conversation going. So first, to return to the quasi-legislative, quasi-judicial formulation from Humphrey's executor, was there any textual or historical grounding in the Constitution for these distinctions, or did this emerge primarily as a pragmatic response to the growth of the administrative state?
Yeah, I'll just jump in and say that there was no real textual or historical analysis to support those distinctions in Humphrey's executor. Scholars have subsequently tried to argue that there was support in the court's own case law going back further, long before Humphrey's executor. And that may or may not be right, but in terms of the actual constitutional text or its history, both at the ratification period and in subsequent practice, there really is no support for the quasi-judicial, quasi-legislative categories as taking officers outside of the president's removal authority. Now, the idea that there are executive officers who perform tasks that look adjudicatory in nature, for example, and in that sense could be described as quasi-judicial. No one, I think, denies that or really has denied that since the founding. Madison himself has described the comptroller of the Treasury as being somebody who had functions that seem judicial in nature, and that makes sense because of the nature of the task that some officers have to perform. But what's notable about Humphreys is that it takes that description and then uses it to recategorize officers as not subject to the president's direct supervision within the executive branch. That really is novel and not something that the text or history supports, and that Humphreys didn't claim the text or history supported.
Aaron or Stephanie, anything to add to that?
Agree with all that. Yeah, go ahead, Stephanie.
Sorry, that this, as Joelle alluded to, the Saylor Law majority was pretty explicit that Humphrey's executor reasoning hasn't held up very well over time, and that the idea from that 1935 opinion that the FTC exercised no part of executive power probably didn't make a lot of sense then, but makes even less sense now. And just the court, including in Justice Thomas's concurrence and joined by Gorsuch, talked about the ways in which the Constitution doesn't permit the creation of officers exercising quasi-legislative and quasi-judicial powers in these sort of bizarre combos. That's just not anticipated by our constitutional framework.
So another question, some argue that removal restrictions protect stability and neutrality in these independent agencies. So is that something that courts should be weighing when they evaluate claims in these different removal cases?
I can jump on that one. I don't think so. Our constitutional text doesn't say, take care, the executive shall take care that the law be faithfully executed, unless a majority of the court determines that pragmatic concerns outweigh the Constitution. So those sorts of concerns come out of the genesis of the administrative state, this idea that we want experts to decide things rather than representative democracy to decide things. And to me, really illustrate part of the problem. We lose that accountability. We lose the opportunity for we the people to have a say in the policies that really matter. And as the government's brief points out, everything from employment decisions to you name it. If you're talking about a rule that affects real people, more often than not, that has been enacted by an agency. And if that agency head is not accountable to the president, that means that person is not accountable. Those agency rules are not accountable to you or me either. So pragmatics are great, but not when compared to the constitutional duty of the president to take care that the laws be faithfully executed, which he or she cannot possibly do unless they are able to supervise those agencies.
And if I could just jump in and just add to that and say, I think that one of the sort of conceits of a lot of administrative state defenders is to presuppose that many, if not most, public policy questions are susceptible to neutral, objective solutions that are not themselves political in nature. And I think that really is a political theoretical disagreement between a lot of defenders of the administrative state and a lot of critics of the administrative state, along the lines of what Aaron was just saying, that it's not just the point about accountability. It's that accountability matters precisely because these agencies are making rules or regulations that are politically controversial, that implicate deep questions of the common good and how we ought to govern ourselves as a society. And so they might support their conclusions by citing empirical studies, and surely there are empirical studies that do support some of those decisions, but the empirics themselves do not dictate the answers, because there are always going to be trade-offs and the weighing of different kinds of goods that are quintessentially political questions, and those should be made by some sort of politically accountable official.
could you talk a little bit about, there are multi-member commissions and then there are agencies that are headed by a single individual. Does Article 2 require, a uniform rule for both, or could there be some distinction between how the two are treated?
I'll just say briefly that the fact that the court thinks that there, or at least signaled in Wilcox, that there might be a unique history for some agencies like the Federal Reserve, I think suggests that they are willing to consider the agency structure and the particular history surrounding that structure in whatever rule they craft moving forward, assuming that they either significantly limited Humphrey's executor or overruled it entirely. I don't think that those distinctions about like the historical functions of agencies will turn primarily on is it multi-member or single member. So I think that's a big question, and what will they focus on? What will the test look like? But there's no important constitutional grounding for why single member versus multi-member needs to be the key constitutional difference.
So are
Yeah,
there, oh, go ahead, Erin.
I was just going to jump in and say I agree with that. And that's one place I think respondent Slaughter might overstate things. She relies on free enterprise to basically say that the court sanctioned multi-member groups of commissions in overruling the double for-cause removal protection at issue in that case. That, of course, was the question presented there, but I don't think free enterprise suggests that a multi-member commission might not also be problematic.
So I'd love to hear your thoughts on if there are potential off-ramps the court could take short of overturning Humphrey's executor. Are there ways they might limit the ruling just to the FTC, but leave removal protection in place for other independent agencies?
One argument Elon Werman has made in an amicus brief is that perhaps you could have non-judicially enforceable for-cause restrictions that could permissibly provide some way of something short of completed elimination of independent agency protection, but there might be a political cost if the executive decides to ignore those sorts of limitations, not necessarily a judicial one. I believe Aaron Nelson has made a similar argument elsewhere. One other thing that I want to point out that's interesting in the Slaughter case is that it's not just a question of like what should we do with Humphrey's executor. That's one of the issues. The other issue is, unlike Humphrey's executor, where the official there was just seeking, his estate was seeking back pay, here Slaughter is asking to be reinstated. And so one of the questions is, does the judiciary even have the power to, like, under their equitable power and their constitutional role, to force the executive to reinstate an official? And so that's a different off-ramp and an interesting angle in the case entirely as well.
Do you have thoughts on what, short of reinstatement, are there other possible remedies the court could look to if they did rule for Slaughter?
Sorry, is this a question for me or the other panelists?
I'll kick this for anybody. Anybody.
So sure, I can jump in a little bit there. So I think there's a real debate between, courts of equity today under Trump versus Casa have to identify sort of historical equitable powers. So the parties debate whether mandamus would have permitted reinstatement. The government, seems to have a pretty strong case that if you reinstate someone, that really, if we think of Article 2 as giving the president the ability to take care, that seems to have the same sorts of problems as would limiting a removal power. Probably since there are similar powers that the other side accuses the DOJ of sort of, double counting these Article 2 harms. But short of reinstatement, the obvious example is back pay in Humphrey's executor. Under the various civil protection statutes at issue here, I'm not sure Slaughter actually qualifies for back pay, but that would be something that is potentially available for certain officials.
So with the argument on Monday, which justices should we keep an eye on? Which ones are the bellwethers for how the court may rule?
So yeah, I would be looking for the ones that we seem to always be looking for. Justice Barrett is very interested, of course, in the historical analysis, has gone back and forth with other justices on that. And one thing to note for listeners is that Caleb Nelson and Professor Hamburger have sort of sparred back and forth about the original meaning of the take care clause and whether that is actually inconsistent with this idea of requiring at-will removal. So you might hear some questions about that, sort of pressing on, are our assumptions about Article 2 as explained in SELA law, are those correct? Or is there some new original evidence that suggests something different? So I imagine Justice Barrett will press on that. And Justice Kavanaugh is cited a number of times in Ms. Slaughter's brief, talking about sort of the long-standing nature of independent agencies, and so folks will be paying attention to his views. The Chief Justice obviously wrote SELA law and a lot of these other cases, so has traditionally been pretty forceful in separating. He has a high view of separation of powers, but will be interesting to see whether he thinks this is any different.
Yeah, and just to add to that, given the previous positions we've seen from the chief in SELA law and Justice Kavanaugh, including when he was on the DC circuit, and then Justice Thomas's concurrence in SELA law joined by Justice Gorsuch, like we have a pretty strong indication that those justices have a dim view of Humphrey's executor. I will be interested to see, Caleb Nelson is Justice Thomas's former clerk, and he's arguing that the necessary and proper clause does give Congress authority over removal, and as Aaron pointed out, making interesting historical arguments about that. So I'll be interested to see. I think some of that's likely to come up in argument, and if so, how Justice Thomas himself engages with that. But I think that Justice Barrett's vote will likely be pretty important in this case, and also seeing how far the chief is willing to go. Is he going to want to do something he often does, which is just like continue death by 1,000 cuts of precedent, or is he going to feel like we've had enough cuts, we're at 1,001 now, because truly there has been a lot of cases that have whittled away at this precedent, and now it's time to give more clarity, because you certainly see the chief sometimes get to that point, or assign the writing to another justice who's ready to do that as well, in cases that the court has overruled in the past 5 years or so.
So if the court overturns Humphrey's executor, what does this mean for the activities of agencies that are premised on impartiality and independence? In-house adjudication proceedings where you have ALJs. Would this mean that political leadership could direct all of those activities?
So I think that it would mean that any decisions that come out of an agency would ultimately have to be accountable to the agency heads, and the agency heads would ultimately be accountable to the president. Um, to the extent that that disrupts the assumptions undergirding the way some of these agencies operate, that would seem to indicate a role for Congress to step in and say, well, maybe we need to rethink the way some of these agencies are structured in light of the fact that the heads of the agencies are now removable at will by the president, and that the other agency officials are subject to supervision by the agency heads. I will just say that there is one pretty important issue that qualifies the potential reach of all of this, which is that in Myers itself, the court did distinguish the situation of inferior officers, and Morrison also distinguishes inferior officers as being in a different category. So does SELA law. And so this case in Slaughter is really aimed at principal officers. So it is theoretically possible that the court could hold that principal officers are subject to at-will removal by the president, but inferior officers in a future case, they might say are not, in which case a lot of lower level officers could potentially be protected by for-cause removal restrictions. Excuse me. That is the way in which civil service protections, for example, have often been justified, is through this inferior officer holding of Myers in subsequent cases. I'll just point out that I think that as a historical matter and as a textual matter, leaving aside the court's case law, which obviously matters quite a bit, but as a textual and historical matter, I think it's harder to justify the distinction between principal and inferior officers with respect to the president's removal authority. But my point is simply, given that you were asking what follows from this decision in Slaughter, it doesn't necessarily follow that all the way down the chain of command, everyone is subject to at-will removal all the way up to the president's authority, because that inferior officer question will remain open, I think, after this.
If I could just add to that, so some different off-roads we've been kicking around a little bit, but just to summarize some of them. Of course, there could be a world in which the answer is just the president has removal authority over everyone within the executive branch, and that's that. The court could sort of draw from Humphrey's executor to say that it needs to be something like significant executive power. They could narrow Humphrey's executor to like a pure adjudication context. They could do the remedial off ramp we were talking about earlier, where they would just say that for cause protections are constitutional, but the court lacks power to enforce them through something like reinstatement. Or you could have the more extended Werman version of non-judicially enforceable at all, not just for reinstatement, but even for something like back pay. So it's just a political cost. You could also say that there's a unique historical pedigree carve out. So the default would be the president could exercise removal power, generally speaking, unless this particular type of agency, which maybe the Fed falls under, has a unique historical pedigree where there's some understanding that the framers thought, or early constitutional history suggests that it was accepted that there would be limitations there. And then, as Joelle alluded to, there might be differences for principal versus inferior officers, how we treat a removal there. I'm probably most attracted to the unique historical pedigree approach, but the point is there are a number of different options, and overruling Humphrey's executor or significantly limiting it even more to its facts, so it's essentially Bivonized, does not necessarily mean that there's just one other option beyond that where the president is going to be able to remove everyone from every agency.
Just to add one small thing to that, there is a textual difference between the inferior and principal officers. The appointments clause, of course, talks about appointing principal officers, but it leaves Congress as well as even the courts or the heads of departments to appoint inferior officers. So the court, there is that textual hook that would, as someone said, justify the civil service system and those sorts of things. Then the question gets into, well, what sort of policymaking authority is permissible under Myers and other cases.
So could you all talk a little bit more about the Fed? We do know that there is going to be a case argued, I think in January, Trump v. Cook, where the president has removed one of the members of the Board of Governors. So what implications might this case have? Do you think that's going to come up in the argument on Monday in the Slaughter case?
Yeah, I think that it will come up, but I think that the majority, what I take will likely be the majority in this case, will probably brush that aside pretty easily by saying, look, we've said previously, including in the emergency docket, that raises distinct issues, and so it's not necessarily governed by what we do here. I think that the two quick additional points on this. One is the Cook case in January. It really is a very different set of issues, because there the government has relied solely on the statutory argument that the president did in fact comply with the statutory removal restrictions on the Fed governor, saying that there was cause for removal, but not arguing that the president's inherent Article 2 authority justified that removal. So I think that's a pure statutory question in January, and not one that really implicates this question about the constitutional power to remove. In terms of whether the Fed is sufficiently different from other agencies to justify a different result, I don't think the court has said that it's different. It has simply left open that possibility. And an article by Aditya Banzai and Aaron Nielsen, which looks at this in great depth, I think shows pretty pretty persuasively that the modern Fed is not sufficiently different from other agencies to justify a different result. So it does seem to me that if the court overrules Humphrey's executor on the basis of text and history, the reasoning of that opinion should justify, excuse me, the president also being able to remove any Fed governor at will, given the way the Fed is currently constituted. But obviously, that'll be a contested issue for a future case potentially.
And I think one interesting thing too about, I would recommend that article highly to interested folks, is that they are speaking, Nilsson and Aditya, about the currently constituted Fed. So they point out that the sort of structural sorts of powers that folks are most worried about when thinking about the Fed and not being independent, that those sorts of powers are likely justified by historical sorts of rationales that Professor Barclay was talking about. But you do have this enforcement authority, this rulemaking authority. So they leave open the possibility that perhaps what could happen with the Fed is to carve out those sort of unique banking functions and separate out the more executive type things that are not justified by historical practice. So super interesting article. A lot of the questions, I agree, will not be fully explored in this case, but we'll have, we'll and also won't be explored in Cook for the reasons that Joelle said, but something to be on the lookout for.
So it's prediction time. How soon do you think we will see a decision in Slaughter? And would you like to hazard a guess at how any of the justices may vote?
I suppose I'll just say I would predict 6-3, sustaining the removal. I think overruling Humphrey's executor explicitly, and I don't think that there's any real rush since there's emergency relief in place. So I don't think there's much of a rush on the court's part to get out the opinions. And I suspect that Justice Kagan, who has been a real defender of independent agencies and wrote a very extensive dissent in Saylor law, insofar as it ends up being a majority opinion along the lines that I just sketched out, that she will probably come ready to write a pretty extensive dissent. And so I could imagine it could take a while before we get the decisions on this, maybe not till June.
It's just one brief thing to emphasize about that, because we've passed over it quickly, but because the court did already grant the emergency stay in this case, 6-3, overturning what the lower court had done, where they would have tried to force President Trump to reinstate Slaughter. I think that gives us a really strong indication of, like, we know how the story ends. Probably that vote lineup will stay the same. It's just going to be most interesting to see on what basis the court is going to rule and what sort of guidance they give forward with respect to other agencies. And for reasons we've talked about, they probably won't say all the things because they're going to have more to say about that in the Cook case in January.
Aaron, any prediction, or you agree 6-3?
I think that is probably the likely result, again, because we have that stay order. I think we're certain that 3 justices will likely dissent, given that 3 dissented from the stay. And occasionally, stay orders and merits opinions change in vote count, but that's not common.
Now, I understand the DC Circuit issued a ruling in I think the Harris and Wilcox cases this morning. Has anyone had a chance to look at those? Is there anything in there that might pique the interest of the justices come Monday?
I've not had a chance to look, but I do think it's interesting that they went ahead and got it out, because they certainly could have justified waiting on the Supreme Court's decision here. So interesting that the DC Circuit went ahead and got it out, especially just on the eve of argument. So.
Mm-hmm. All right. Well, I think we've we've exhausted most of the questions. So does anyone have any final thoughts you'd like to offer?
Could I just say really briefly, we've been talking a lot about what the Trump administration has done, but I think it is interesting to keep in mind that the Biden administration removed a lot of officials from agencies that have traditionally been viewed as independent. So he removed the NLRB General Counsel, Peter Robb. He removed the FHFA Director, Mark Calabria. I'm not sure if I'm saying that last name right. The Social Security Administration Commissioner Saul, and a number of others. And these are examples that the Trump administration is pointing to now to say this isn't a partisan issue. The executive needs to be able to remove people that are exercising executive power if those people aren't doing it consistent with the preferences of the voting American people. They have to be accountable to someone, and if not the president, then who? And Biden recognized that, and Trump recognizes that now, and other presidents in the past have recognized that. And this is just sort of a bipartisan need to make sure that we can faithfully execute the laws.
Yeah, along similar lines, I'll just jump in and say that there are a lot of things that President Trump has done that strike some observers as aggressive exercises of executive power. This actually really isn't one of them. I mean, this is an action that the president has taken and a legal theory that the president has put forward that was the dominant view of presidents all the way up until including FDR, right? The FDR himself had that view in Humphrey's Executor. It's a well supported historically and textually supported position, and whether one agrees with it or not, it's certainly not a radical position. And if the Supreme Court vindicates the president's view here, all it will be doing is restoring the state of constitutional law to what it was before Humphrey's Executor and had been since the founding. So I don't think that this case should be viewed as a kind of uh, exercise of aggressive or groundbreaking or novel executive power by this president. And I don't think that the court vindicating that should be viewed as something radical either. It really is just a restoration of what had been the constitutional default rule for a very long time.
I love that point so much. I think that's exactly correct. And I think it also bears in mind that that's what the court has been signaling for the last 10 years. They may have done it incrementally, but seal of the law, I think, arguably overrules Humphrey's Executor. As folks have noted, it says that that decision has not stood the test of time. It says that certainly now the FTC exercises at least substantial executive power. So the Trump administration has a very good case that under state law, much less these historical principles, it's not pushing boundaries here.
One final question from an audience member. They'd love to read the article about the Fed. Is that by Adichie Bamzai and Aaron Nielsen? If you know the title of the article, that would be helpful. If anybody knows it offhand.
What is it?
If not, I'm sure our audience member can Google their names and the Fed and find it pretty quickly. Well, we've come to the end of our time. I want to thank our panelists and thank everyone in the audience for joining us today. Monday should be an exciting oral argument that you don't want to miss.
Wonderful. Thank you so much to our panelists for joining us today and sharing your expertise and insights. Elizabeth, thank you so much for moderating this excellent conversation. If our audience is interested in learning more about all of our programming here at the Federalist Society, please visit our website at fedsoc.org, or please feel free to send us your feedback. We always love to hear it at fedsocforums@fedsoc.org. Thank you so much. Bye-bye.